Welcome. A federal appeals court has ruled that California's voter-supported law requiring police to take DNA is constitutional. My guest is retired Superior Court Judge in Santa Clara, California, Eugene Hyman. Judge Hyman, it's good to see you. Welcome back.
Thank you.
All right, talk about taking DNA and talk about how that compares to fingerprints.
Well, it's sort of an interesting process in terms of how the case has been decided in different venues. It was decided at the Court of Appeal level, the state Court of Appeal level, held that the law was unconstitutional. The prosecutor then appealed it through the federal system, and the case wound up before a three-judge panel of the Ninth Circuit. And the Ninth Circuit voted 2-1 that it was constitutional. And the circuit judges, the majority, decided that it was a minimal intrusion because it was a buccal swab. In other words, a Q-tip inside the mouth collected cells that could be used to determine DNA markers. And the court held that that was no more intrusive than taking fingerprints. But if you look at the history, the appellate history behind fingerprinting and DNA, they just as easily could have come to a different result as suggested by the dissent. Police cannot arbitrarily collect fingerprints from anyone. If they were arrested and if there's probable cause, then it's appropriate to take fingerprints. Hypothetically, though, if the police wanted to take a fingerprint sample from someone because they wanted to see whether or not they were at a crime scene, they would need a search warrant in order to do so if that person had not previously been arrested or wasn't being arrested for the crime that time. The other thing with respect to DNA evidence is that it would be kept even if you were found not guilty or even if the charges were dropped, and it would be part of the permanent system. Unlike fingerprints, DNA can also be used for a familiar family representation. So maybe you were arrested and the DNA hit on a cold case. You were not the perpetrator, but someone in your family was. So that can be used to identify perhaps a family member who is not in the system is a possible perpetrator. I think that I've got no problem with it if you're convicted of something, but if you are found to be not guilty or if the charges are dropped, to have this in the system seems to me to be inconsistent with our basic principles of no unreasonable searches and seizures, no matter the fact that it's not a significant intrusion because it only takes a second. And actually under California law, if you don't voluntarily give it when you're requested, they can actually take it by force. It actually can be charged as a separate crime, refusal to give DNA evidence. And it just sort of concerns me that it's an extension of what the government can do without having to have some minimal evidence in terms of probable cause.
Thank you, Judge.
Thank you.
My guest is retired Superior Court Judge Eugene Hyman in Santa Clara, California, and this is the Family Law Channel on the Legal Broadcast Network.